Hey, good afternoon, everybody. We're back for Higher Education Subcommittee. Today is Monday, March the 11th. Madam Clerk, would you please take the roll?
Representatives Baum, Butler,
Here.
Gillespie, Haston, Love, Parkinson, Chairman White, Chairman Lafferty, Chairman, you have a quorum.
Thank you very much for that. Members, starting off, do we have any personal orders? Oh, Representative Gillespie, you're recognized.
Thank you, Mr. Chairman. I just wanted to point out that another chairman in the room has a birthday today. Wanted to wish Chairman White a very, very happy birthday.
Happy birthday, Chairman. Might as well go. Might as well go ahead and recognize another birthday boy in the room. Down there on the far right, Chairman Haston, happy birthday. We know you love the attention. All right, members, we've got 11 bills on the calendar today. Do some housekeeping real quick before we get underway. Item number 3, House Bill 2116, is going to be rolled. Item number 4, House Bill 2488, will also be rolled. Item number 7, House Bill 2276, will be rolled. And item number 10, House Bill 869, are rolled to the lottery/scholarship calendar. And we'll go ahead and do that. Let me announce also, before we get to our bill, next week's going to be our final calendar. It's going to be heard with the lottery and scholarship calendar. If you have any more higher education bills, please get those on notice. Having gotten that part out of the way, we are back to the top. Item number 1. Chairman Reagan, you're recognized. Do we have motion? We have motion. Do we have second? We have motion. We have a second. Chairman Reagan.
Thank you, Mr. Chair and Committee. Straightforwardly, what this bill does is prohibits universities from creating anti-discrimination policies inconsistent with policies recognized by the state law of Tennessee. It's critical that all taxpayer-funded institutions have one consistent policy. Protected classes are those which are defined in our state law as protected classes or law in general. Those institutions which attempt to create protected classes under the color of law are in fact doing a disservice not only to their student body and their faculty, but to the entire state of Tennessee. What this bill does, quite straightforwardly, is say that they cannot recognize protected classes that the state does not recognize. And they may do so only to the extent and the forms of discrimination that are recognized in the state as legally actionable. This is found in TCA Code 4-21-102, which defines discriminatory practices as meaning any direct or indirect act or practice of exclusion, distinction, restriction, segregation, limitation, refusal, denial, or any other act or practice of differential or preference in the treatment of a person or persons because of race, creed, color, religion, sex, or national origin. And this bill is about ensuring that our universities are in fact adhering to the state law. Some have raised objections on the grounds that they think they have to provide special recognition to some other particular classes, and we have had a ruling from the Supreme Court that has confused the issue. However, I did some research on that, and I have a quote for you here from Westlaw, which is the program we all have access to. This is the Westlaw Notes of Decisions. The Supreme Court, however, expressly limits its decision on Bostock to consideration of whether or not an employer who fires someone for simply being homosexual or transsexual has discharged or otherwise discriminated against that individual because of such an individual's sex, noting that that individual transgender status was not relative to employment decisions. The Sixth Circuit, by the way, the court has also expressly declined to address other issues such as bathrooms, locker rooms, or anything of the kind. The Sixth Circuit has cautioned against applying the Bostock decision outside the context of Title VII, which is employment law. Furthermore, other court cases within the Sixth Circuit have also followed that rule. And in fact, one here in Tennessee said it does not follow that the principles announced in Title VII context automatically apply to Title IX context. In short, there are some of our universities that are trying to expand on a decision from the Supreme Court into areas where the courts themselves have said it does not belong. And this law is about making it very clear that they do not have that authority. That authority rests with this body, the General Assembly. With that, I probably should have mentioned I have an amendment, sir.
I was just about to ask, and I should have covered that beforehand. It doesn't look like the amendment rewrites the bill.
No, it does not.
And what is your drafting code, sir?
It's 15122.
That is what I'm showing here as well. Let's go ahead and put the amendment on. All those in favor, all in favor of adding the amendment indicate by saying aye. Any opposed? Ayes have it. Amendment's on the bill. You want to give us a brief,
This amendment just basically adds that the Tennessee Higher Education Commission shall promulgate rules in consultation with the Department of Finance and Administration to include emergency rules to effectuate this act. Add the words in consultation with the Finance Administration.
okay. Thank you for that explanation. Members, do we have any questions on the bill? I'm curious, it sounds like we're trying to make an effort to not create something that doesn't already exist in the law. Am I getting that right?
Yes, sir, that is exactly what this bill is about. By way of explanation, members, each July, the agencies of our state government are required to submit policies for the review of government operations chairs, both Senate and House, and the ones that they have changed in the previous year. In reviewing those policies, some of our LGIs, our locally governed institutions, indicated that they were instituting policies to protect classes that are not mentioned anywhere in state law, or for that matter, in federal law, with the exception of what I just read. And this bill is about making it clear to them that they do not have that authority.
I'll follow up if nobody else. Oh, Chairman White, go ahead. Thank you. I was going to see, have you reached out to those institutions? Are they to indicate to them all that you've shared with us before we got to this bill point?
Yes, sir.
Okay, thank you.
They have indicated that they wish to do whatever they want to, regardless of what the General Assembly wants to do.
Interesting. Okay. Thank you for that. Chairman White, you're recognized.
Thank you, Chairman. Yeah, and thank you very much, Chairman Reagan. I always appreciate your ability to really get down because of your background and everything. Somehow, it has come to my attention, and we're moving fast right now, and I don't have a lot of the detail even at this point. Is anything in this legislation put us out of sync with federal law that could cost them, the institution, to be fined, cost them money, or lose federal funding?
You're recognized.
Thank you. Despite their protestations to the contrary, no. We, in fact, have a court case from right here in Tennessee, the Eastern District of the Federal Court by Judge Ashley, which if you want the citation, I can give it to you. But Judge Ashley specifically put an injunction on one of our LGIs, which I'll be glad to read if you want to hear it, about trying to create this protected class because of the federal government's insistence on saying it was, when Judge Ashley pointed out the federal law didn't say it was. That injunction is still in effect.
Chairman White.
And in spite of that injunction, we have members of our education communities that are attempting to do that. In fact, it's in their policies.
Thank you.
And I also mentioned, in spite of a letter I sent them citing that court decision to them.
Thank you for that. And I'm not an attorney, but that almost sounds like precedent to me. Would that qualify as precedent
You're
for
talking about excuse me,
the Sixth Circuit opinion
well,
or the stay?
This was the Eastern District Court of Tennessee.
Okay,
And of course, obviously, as a district court, it's subject to appeal, and our legal counsel can pass that on to you. But at this point in time, that was based on a rule change that the U.S. Department of Education attempted to push through. Judge Ashley put an injunction on it because it did not conform to the Uniform Administrative Procedures Act. They have since attempted to promulgate rules again 2 times, and in both cases, the most recent one I'm aware of, their rules got over 395,000 public comments to the contrary, and they have not yet implemented those rules.
okay. Thank you. Members, Chairman White?
Just one more. Thank you. So moving forward, like the notes I had, is that like the higher education lawyers just don't agree with our assessment of what we're doing. So any balancing out there as you're working through this to get the legal counsel from the universities on board with what you're trying to do?
You recognized.
We have 6 LGIs. 3 of them have indicated no problem with what we're trying to do. 3 of them are basically saying, we don't care what you say.
Okay, and this is private also, right?
No, I'm not.
This only affects public or
This
private?
affects universities that are state chartered, state supported, or that are taking money from the state, as in Hope Scholarship.
Thank you.
All right, thank you for that. Chairman Love?
Thank you, Mr. Chairman. Your last statement, I maybe now think about this. What about private schools that take Hope Scholarship?
You recognize.
This would affect them.
Okay, thank you.
Okay. Members, any other questions? It's just shortest summary you can provide what we're doing here, because there's a lot in this. Could you just close this out with a quick?
All right, very quickly, this says that our state institutions of higher education are not empowered to create their own definitions of protected classes. That's it in a nutshell.
Thank you for that. And they certainly shouldn't be ignoring us when we make requests of them either. All right, thank you, Chairman. With seeing no further questions, members, we're ready to vote. All those in favor of House Bill, excuse me just a second, lost my place, of House Bill 1660, please indicate by saying aye. Any opposed? No. The noes have it, Chairman. I'm sorry.
Thank you, Mr. Chair and Committee. I appreciate you listening to the presentation.
Thank you. Item number 2, we have a request in to roll that for 1 week. So we will be moving on now. Sorry. Oh, it rolled 1 week. Next up, we'll take item number 5, House Bill 2248 by Chairman Holsclaw. Members, can I get a motion? And a second? We have a motion and a second. Chairman, you're recognized, sir.
Thank you, Chairman. And probably just a quick note, this committee probably has more chairman on it than any group we have. I think about everybody up there is a chairman, so. Basically, HB 2248 is a simple bill. It's a cleanup bill from last year that we passed. All this bill does is it includes the Tennessee Academy of Family Physicians to aid the Department of Health to administer the student program, the loan program.
That's it.
Pretty much.
Okay. Members, I know there's a lot to swallow there. Do we have any questions? Seeing none, we're ready to vote on House Bill 2248. All those in favor say aye. Aye. Any opposed? The ayes have it. And you will be moving on to Education Administration.
Thank you, Chairman of the Committee.
Thank you, sir. All right, members, next we're going to take up item number 6, House Bill 2743 by Representative Stevens. We have motion. We have motion and a second. You are recognized, sir.
Thank you, Mr. Chairman. This legislation seeks to ensure that military families can receive the benefit of in-state tuition should a reassignment result in a temporary family separation. Everyone must be a U.S. citizen or lawful permanent resident, and the legislation mirrors the one-year residency requirement for in-state tuition rates, but applies the residency requirement to the service member and not to the student. And so an example of that would be if someone in the military is assigned or reassigned to a place in Tennessee and is here for a year, but their family stays back home so that their students might finish high school there or whatnot. When they come to Tennessee, they'll qualify for the in-state tuition based on the service member having lived here for 1 year.
Okay. Thank you for that explanation. Members, any questions? So, Representative Parkinson, you're recognized.
Thank you, Mr. Chair. I just want to tell the sponsor that's a good bill. Appreciate you bringing it.
Thank you.
And I guess this kind of came out of, we've got Fort Campbell to the north of us. I know we've got an air base in Knoxville. I imagine there's another base or two in the state that I'm not aware of, but that'd help out a lot of folks. I've got a Navy base too. Oh, fantastic. I learn something new every day. Members, any other questions? All right, seeing none, we're ready to vote. All those in favor of passing House Bill 2743 indicate by saying aye. Any opposed? And the ayes have it. All right, you'll move on to Education Administration.
Thank you.
Next, we'll take up item number 8 by Chairman White. Need a motion? And second, we have a motion and a second. And Chairman White, when you are ready to go, sir.
Thank you, Chairman and committee. I'll come down here so everybody can see me. The first one we're taking up is House Bill 2287. I believe, or all the amendments. I don't think there's any amendments in place on this. Okay. Okay, we're good. So I'll just go ahead and explain the bill. Members, I'm bringing this on behalf of, at the request of the University of Tennessee. And here's the issue that I wanted to lay out before you. In 2018, in the Focus Act, we set up advisory boards for the 5 UT campuses across our state. And so, and each of these advisory boards has 5 members. Now, each campus has 5 advisory board members with no governing authority to make decisions, but only recommendations. And I remember voting on this back then, and I said, well, this is a good idea because you've got advisory board members that are in Northwest Tennessee that would help with UT Martin down in Pulaski or in Memphis with UT Health Center, Healthcare Center. And I said, good idea. But like I said, they have no governing authority. We only make recommendations back to the UT system. Of course, these have been appointed by the governor and we have been approved in the House. So here's the issue that's coming. Because of this 25 board members, advisory board members that are appointed, the governor has to appoint and then we have to approve while we're in session. And with those that are, say, rolling off or just dropping off, it's kind of come a halfway system where there's not enough people a lot of times, and then they have to wait till the governor appoints, the board of commissioners appoints again, and then we approve. And so what the bill is asking for, they would just like for the university president to appoint the advisory board members for each of these schools and the various parts of the state, so that be a less bureaucracy, be able to go ahead and just put people in place that you can get things done without waiting on the system to thing. So that's what the UT is asking for, to move away from where we as the governor appoints and where we had to approve. And with that, I just opened up for discussion.
Thank you for that explanation. Members, do we have any questions? Not seeing any questions. Just real quick, it was brought to you by the university itself, right?
It was brought to by the university. They were asking this, think there'd be a much more fluid system since these members don't have any governing authority. There's advisory, and instead of waiting on us and the governor to approve, I know there's a lot of boards and commissions out there, and I know a lot of these things it gets really backed up. So they just feel like they could appoint these from within the system and do the same thing without going through the process. And that's what I have before you.
Okay, thank you for that. So this wasn't an administration bill. The governor didn't come up with it, or his office, and no other legislators came to you and said, hey, this is a lot of work. We don't want to do this.
No, all I would say is I've got written in my notes here, this has passed on the Senate floor already. That maybe I shouldn't have brought that up, but it has passed over there. And I do have leadership, but and Representative David Hawk, who shepherded through the UT Focus Act of 2018, doesn't have an issue with it. But anyway, bringing it on the behalf of the UT system.
Okay, thank you, Chairman. Members, any other questions? Seeing none, we're ready to vote. All those in favor of, oh, excuse me, lost my place again. All those in favor of House Bill 2287 indicate by saying aye. All those opposed?
All right.
Let's back up. Let's try this again. All right, we're voting on House Bill 2287. All those in favor of House Bill 2287, please indicate by saying aye.
Aye.
Any opposed? The ayes have it. We'll move on to Education Administration. Next up, we have item number 9, House Bill 2561, also by Chairman White.
Thank you, Chairman and committee.
Can I get a motion? And second? We got a motion and a second. Chairman White, please, you're recognized.
Thank you. We're working on Amendment 15377.
Yes, sir, that's what I have. We have
Okay.
motion and second on the amendment. Let's go ahead and put the amendment on there while we've got you a second. All those in favor of adding amendment 15377, please indicate by saying aye. Any opposed? Ayes have it. Amendment's on the bill.
Okay, thank you. And committee, what we're trying to do here, this is also brought to me by one of our universities, public universities. And what it is, it's asking if a state university board, especially we're talking about in our LGIs, basically, if a state university board determines that there is a need for the board to discuss sensitive topics, then the state university board may conduct an executive session that is not subject to open meeting requirements in Title 8, Chapter 44, to discuss the sensitive topics. And if a state university board intends to conduct an executive session pursuant to the subdivisions in the code, then the board must provide reasonable notice to the general public prior to such a meeting and must not discuss or deliberate on any issues or subjects in the executive session other than these sensitive topics. Like we all know, there are topics a lot of times that come up that they have to discuss that really don't need to be out in the public or the press. If they're talking about maybe appointing a new president, or there may be a lawsuit and things, and they just need the opportunity to have an executive session where the board can meet amongst themselves and talk about these things. Right now, technically by law, they're prevented, and this makes it very, very difficult to conduct business. So they're asking for, if we go pass this particular legislation, to allow them to have an executive committee when needed. With that, I renew my motion.
Thank you for that explanation. Representative Love, you're recognized, sir.
Thank you, Mr. Chairman. To the sponsor, will the determinations from the executive session be made known to the public after they come out of executive session? So if a board wants to go and discuss a sensitive nature subject matter and they go into executive session, once they come out of that and a determination has been made, will that be made known to the public or will that stay closed and private?
I would think the best way for me to answer that, it would probably depend on the issue. It may be a process, like if you're getting whittling down to who you might like to invite to for your next university president. That may be a process of months. So I would say you wouldn't come right out at that time, or maybe issues a lawsuit. There may be occasions where they're trying to make a decision. I would say it depends on the situation, maybe eventually. But from what I understand, how, just like we do things around here, it may be a sensitive nature that you would not want to discuss. You're really just trying to flush it out and help the board to understand exactly what you're up against.
You're recognized.
Thank you, Mr. Chairman. Just to follow up. So, and I'm reading it here, I guess at some point, maybe, I hear your concern that it might not be available the next day, but at some point, I would think that maybe even the minutes of that meeting, I don't know if they're going to conduct minutes in that meeting and record what happened, but I would suppose there would be some type of recording of the deliberations. Maybe not. I just wanted to find out what would be the posture of the information in that executive session.
I would say yes. They would have to have someone in there that would probably be, taking minutes. Now, whether or not it's ever released, I really wouldn't know. I haven't got down to that depth. Basically, what they're asking is, there are times that we as a board need to talk behind closed doors, and that's all we're trying to get them permission to do.
Chairman Love, any follow-up?
No, thank you, Mr. Chairman. Thank you.
All right. Members, we have any other questions?
May I-
Yeah, please.
Maybe this might clarify one thing for Representative Love. Section A, it says, except as provided in the subdivision of the code, meetings of the state university boards must be made available for viewing by the public over the internet stream. I think you have to maybe say what you're going in there to meet about, so that you're not meeting about things that should be made public.
Okay. Representative Butler, you're recognized.
So I'm curious that this could be definitely be abused, avoiding some of the open records request. I think my colleague up here had a good question, that if these are recorded, would those recordings be made available after the sensitive issue had been addressed, so somebody could go back and watch it? So if they were hiring a president, for example, that you used, 3 months later after they've hired that president, could you go back and watch those videos? or read the secretary's notes or whatever the case may be.
Mhm. You know, that's an issue I may need to get clarity on. You know, when you're talking about things in a sensitive nature, are you really wanting to record it? We all, and when we meet sometimes to talk about things, we want to flesh things out so that before it is made public, we basically know what we're doing. So I'd say if you're working, say, on the appointment of the next president, mainly you're doing it to protect that person. You can't put it out there that you're trying to get this guy, because if he's come from another state, he may lose his job knowing that he's applied to this. So these things of a sensitive nature.
You recognized?
Could we not put some, or utilize this piece of legislation specifically for a couple of items instead of leaving it so broad? Could we just use it for hiring a new president, for example? Obviously, I see the benefit of keeping that confidential, and whomever that individual that's potentially being hired, not losing a job somewhere else, or the salary discussions or any of those things be kept confidential. But I don't know that there's any other incidents that the public wouldn't have a right to know what's going on.
You recognize?
Yeah, I think there, I hear what you're saying. I think there are. I may ask legal, we do have defined in here what the nature of sensitive topics means. There is, have the legislation about 4 topics. But Mr. Chairman, could I ask legal to define sensitive topics in our code, or what could possibly be discussed in this? Is that possible?
Absolutely. Without objection, we're going to go out of session real quick. We're out of session. And legal, if you would please state your name and tell us what you tell us.
Sure. So Mark Dobies, Office of Legal Services. So Chairman White and committee, reading here, it says sensitive topics means item deemed not subject to public inspection under 10-7-503 and 10-7-504, and all other matters designated as confidential or privileged by the laws of the state. Item 2 says current or pending litigation and pending legal controversies to which the state university is a party. Item 3 says pending or ongoing audits or audit-related investigations for the state university. Item 4, information protected by federal law. And item 5, matters which involved any suspected illegal, improper, wasteful, or fraudulent activity at the state university for which an informant has requested anonymity from the state university board.
Thank you for that explanation. Representative Butler, any follow-up question?
No, thank you. I'm good.
Okay, thank you. And anybody else have a question for legal? No questions for legal? All right, we're going to go back in session. We're back on the board. In the context of what we're talking about, the truth is, if folks decided to have these conversations outside of public view, we don't have a way really to police that or to keep an eye on it. This bill seems to me it would keep people from being put in that position where they have to make a decision on whether or not to break the rules. Chairman?
Thank you, Chairman. You're exactly right. That's why it's brought to me. You know, you could possibly do this but the law doesn't allow it, and they really want to work within the law and not, have things that would happen. So that's why they've asked that we run this legislation, is so that when they need to do this, they are working within the law.
Okay, thank you for that. Members, any other questions? Seeing no further questions, we are ready to vote on House Bill 2561. All in favor indicate by saying aye. Any opposed? And the ayes have it. Thank you, Chairman. And next, we'll take up item 11, which happens to be one of mine. So give us just a moment to rearrange things here.
Okay, members, we have item number 11, House Bill 2392 by Chairman Lafferty. Chairman Lafferty, I see no amendments. Do I have a motion and a second?
Motion. Second.
A motion second on your bill. You're recognized to explain the bill.
All right, thank you, Chairman. This bill basically tells our LGIs to provide language to make sure that their students that are military age are eligible for the draft in order to receive their scholarship dollars from the state of Tennessee. It's already done. through our TBR system. And forgive me, it's been a few weeks since I looked at this, but if I recall, when TBR separated and we made the LGIs separate, that was already in the rules at TBR. It is not in rules for all of our universities. This simply tells them to please put that in their rules so that we can be in compliance. And with that, I'll take any questions.
Okay, with that explanation from our chairman, questions? No questions? Any objections? Let's call on the question. Hearing none, all those in favor of moving House Bill 2392 out to full education administration, indicate by saying aye.
Aye.
Opposed? Ayes have it, moves out.
Thank you, Chairman. Thank you, committee. Members, seeing no further business on the calendar today, we're ready to adjourn? We are adjourned.